rights you don't have. We're going to get into the fact that we say that copyrights are a bundle of rights or a bundle of sticks. There's actually 6 different rights that you're given, that you're granted. And so we're going to kind of unpack those and understand what those are, but also the limits and what we can do to protect ourselves beyond the limits of copyright law. And finally, be proactive now and save yourself time and money later. Probably my biggest kind of self-help advice would be to take yourself seriously, and other people will take you seriously. So we're going to be proactive now, and it'll pay off in the future. Super quick. What are IP rights? It's kind of intellectual property is this big umbrella, right? And so let's see. Okay, great. It's a big umbrella, and so there's different aspects. We've probably heard of patents, trademarks, copyrights, and then there's also trade secrets and trade dress. So copyright is an author's right to an original work fixed in a tangible medium: books, architecture, paintings, music. Patents, on the other hand, do cover ideas. They cover new and useful inventions. Trademarks, the Nike swoosh there, they're source identifiers. So they signal to us where a certain good or where a certain service is coming from. Relatedly, trade dress, it's not so much a mark, but it's a packaging, right? So the Coke bottle, we all see that. We don't even need to read the label. We know that's Coca-Cola. And finally, trade secrets. They are the top secret recipes, the KFC spices, the Coca-Cola recipe, basically some sort of commercially valuable secret. So that's just kind of the umbrella, and then we're going to focus today on copyright. If I can get. Okay, so what do copyrights protect? Sorry, I skipped one. Original works fixed in a tangible medium of expression. So what types of works are we going to be covered here? So literary works, books, music, dramatic works, choreographic works, pictorial, graphic, and sculptural works, which is mostly the umbrella that I'm hearing a lot of y'all fall under. So we'll try to hone in on that today. Motion pictures, sound recordings, architectural works. And how long do copyrights last? Well, they'll last for as long as any of us will be alive. It's the author's life plus 70 years. So if I created something today, I would get copyrights in that piece from now until my death, and it would actually go on to my heirs for 70 more years. So let's revisit our takeaways. We're going to jump into takeaway number 1. Copyright law protects creative expressions, not ideas. Let's unpack that a little bit. So an original work fixed in a tangible medium. I'm going to say that over and over again. And so originality, independently created by the author. You have to make it. It has to be original to you in order for you to own the copyright. Pretty simple. And the law doesn't get into, we're not art critics. If there's any sort of minimal creativity, that's good enough for us. You're all good. And the big thing I want to focus on here is fixation. So ideas are not protected, but expression is. So what does that mean? Well, if Toddy and I are having a discussion and I say, Toddy, I really want to make, this sculpture. I want it to make a political statement. It's going to be a gun breaking in half, it's topical, whatever. We can have that conversation. But that's just a free-forming idea. I don't have any copyrights in that, and we could go our separate ways, and she could make one version of the sculpture and I could make another. But if I actually write it out, if I sketch it out, if I show it to Toddy, now I have an expression. Now it's fixed on my paper, and I'm giving it life. So this serves 2 purposes. First of all, we have to draw the line somewhere. Where are we going to start the rights? It's somewhat arbitrary, but we have to start it somewhere. Number 2, it's pretty useful. The law, we need evidence, we need certainty. And so if I can show you a sketch that I drew on a certain day, or I have, notes about a new book that I'm working on. That's going to help me prove that I actually made it on that certain day. So understand that it's not until you actually begin to create your work that your copyrights kick in. And relatedly, if you just talk about an idea, that's not going to be protected. So let's kind of get an example here. Here's a case where we had two artists making glass-in-glass sculptures of jellyfish specifically. Artist number one makes the piece on the left. Artist number two makes a piece on the right. And glass-in-glass sculptures have existed for hundreds of years. It's nothing new. But the idea, you could say, for these is a glass-in-glass sculpture of a jellyfish, right? And so artist number one complained, hey, they're stealing my creative expression. They're stealing my copyright. Well, they took it to court and they lost, because the actual expressive ideas, the way in which the tentacles drop down, the colors, the trim around the outside, these are all different. They're not identical. They share the same idea, but they're not expressed in the same way. So similarly, if you're borrowing from someone else, or if someone else is borrowing from you, try to think about, are they taking the expressive ideas? Are they taking my details, or are they taking my idea? Am I taking an idea from them, or am I copying the actual expression? Here, it was just the idea, so no infringement. But in the next example, there's a little more striking similarity. And the one on the left is the original New Yorker cover from, let's see, 76. Kind of trying to make a political statement. It's a New Yorker's perspective of the world, right? So it's super detailed on the first few blocks, but after the Hudson River, it goes Jersey and then Kansas City and the Pacific Ocean, right? They don't really care. And so if you take that idea, if you explained that idea to someone, they could take that idea, put their own spin on it, and it probably wouldn't look exactly like, or even very close to the New Yorker cover here. But this movie, Moscow on the Hudson, they took more than just the idea. They took the expression. They took the creative way in which the New Yorker artist had expressed the idea. You can see, the court honed in on the perspective, the way that the road is kind of in the middle, and the city blocks on the outside, the font on the and title up at top, and the perspective in the distance. These were all expressive decisions that the original artist made and that the second artist copied. And so this was deemed infringement. All right, so creative ideas, not protected. Creative expression are protected. Number two, know what rights you have, and importantly, what rights you do not have. So as I alluded to earlier, copyrights are a bundle of rights. But when do I actually get my copyright? Well, as soon as your expression is fixed in a tangible medium, automatically you are granted federal copyrights. So that's one thing I love about copyright law, is that unlike patent law and even to a certain degree trademark law, which have high entry costs, you have to hire a lawyer, you have to have the expertise, you have to go through sometimes years of work with the government. Copyrights are free and open for anyone to gain for themselves as soon as you create your work. And there's some certain things that you can do. I'm sure you've all seen the little C with the circle around it. It used to be a requirement, like you didn't get the copyright unless you put this little notice. We got rid of that. We don't have to do that formalities anymore, but it does help you. It's going to help if you should end up in litigation. It's gonna bolster your case. So it's just a good common practice to get in the habit of. Super easy. Copyright symbol. the year of the creation, and the owner's name. That way everybody knows when you made it. You can show that someone else, hey, I made it before you, and it attributes to the author. So although copyrights are granted immediately or obtained immediately, there is a certain process, a registration process that you can go through that I'm gonna kind of walk everyone through here today, and I think everyone should adopt as their own best practice. If you end up in litigation, it's gonna be required anyway, and there's a ton of very important benefits that you get. So we'll get to that a little later. So what rights are included in my copyright? So,
hey Christian, can I jump in quick?
Yeah.
So there's a question in the chat from Marissa. She's based in the UK. Does copyright protection work in the same way outside of the US? For example, in other European countries?
So Marissa, I have a question back at you. Are you saying, does your work in the UK get US copyrights, or?
Yeah, so I actually have a friend that works in copyright, and she said that it works in quite a similar way in the UK, but I was wondering, for example, if someone was in another European country and they copied my work, how would that translate as well, outside of the country that you're actually living in? Because yeah, within the country, it makes a bit of sense. It seems like there is that protection, but more when you, sort of have that inter-country copywriting there.
Yeah, that's a great point. So it's a little bit nuanced, but and it's gonna end up probably more practically speaking, or the practical limitations are gonna come into play before the legal implications. So what I mean by that is that if you're in the UK and you're trying to sue someone from France, the US courts are not gonna have any power over someone who's in France. And so if you want to come to the United States and somehow lure them to the United States and then sue them, then we could probably have a conversation about accessing the US courts. But our jurisdiction ends at our shores. And so, if the art is passing through the United States, if it's online, US copyright laws will apply, but the, kind of like condemning China, that doesn't really do much. China doesn't care because they don't come here and they're not worried about, the United States isn't going to go over to China and serve someone with papers. So the kind of practical limitations on our jurisdiction are going to come into play there. But in terms of the similarities, I'm not super well versed on UK, but I do know that our legal system in general and certain copyright laws all borrow from British law. So copyrights actually used to be a monopoly that the Queen or King granted, saying, hey, you pay me a fee and I'll let you be the only one that can print this book, for instance. So the laws themselves are very similar. I hope that answers the question.
Yeah, thank you.
Awesome. Okay, so what rights are included in my copyright? So it's a bundle of 6. It's just kind of a metaphor that we use, but there's 6 very important rights, some that matter more for some works than others. So reproduction right, pretty simple, copying, right? Copying something that exists word for word, or taking to a copy machine. Derivative work right means kind of recasting. So think Harry Potter book into a Harry Potter movie. We don't want J.K. Rowling to lose the right to make her movies. The distribution right. So not just making the copy, but then selling it. We don't want people to then, oh, I didn't make the copies, I stole them, or someone else made it, and then I just sold it. That's not allowed either. So that's a distribution right. Public performance right, pretty self-explanatory. You can't go perform Hamilton on the side of the street. That's a copyright infringement. Public display right, similar for more tangible forms of art, and also comes into play with kind of digital spheres, and then digital audio transmission right, kind of obviously a new right in the last 50 years or so. So importantly, you can give some of these rights away, you can sell some, you can license some while keeping others. And so when someone's asking you about whether they can purchase your copyright, understand that there's actually 6 different rights involved there, and you can kind of give or keep as many as you want. And so we'll get into that a little more.
Another quick question, Christian. So in terms of like licensing agreements, and maybe you're going to touch on this later, are these the terms that you specifically need, like an artist specifically needs to state in the contract?
Yes and no. So would it be great if you could use the actual legal term, I hereby grant you distribution right for XYZ work for 1 month? Great, that's perfect. But the law is going to understand that even a simple email exchange that comes to an agreement regarding public display of your work for a certain amount of time, they're going to know, the law will know that you were talking about a specific right. So if we can get more comfortable using these terms, and if we can get more comfortable understanding what we can give away and what we can keep, that's great. Then we've achieved a lot here. But don't get worried. If I don't use derivative work right, you can still say you can't make any copies or any similar recasting or transfer. Use some common language there. So that's a great question. Okay, what is not included in my copyright? So we've already talked about this. Ideas are not included. And there can be kind of 2 sides to this. There's functional ideas, and then there's literary ideas. So functional ideas are not protected by copyright because we have a whole different system for that. That's patents. If you have a really genius new idea, go find a patent lawyer, get a patent. It's not a copyright. I'm kind of a coffee nerd, and so especially in quarantine when I haven't had much else to do, and so if I were to tell or write out a step-by-step guide to how to make the best French press cup of coffee, I can't just write that out and then basically prevent anyone else from using that or describing that same process. Because that's an idea. Now, if they copy the exact words that I use, maybe. But the idea behind my process of making a French press cup of coffee, not protected. Work of others, derivative work rights and compilations. We're gonna get to that in the next slide, but that's not included. If you're changing someone else's work or compiling other people's work, that's probably not included in your copyright, and you're gonna need permission to do that. Number 3, functional aspects. So you've probably seen that bike ribbon, the bike rack, and it actually won a ton of design awards all across the world, but it wasn't copyrighted. Someone took it to court. They said you copied my design, and the court said sorry. It's inseparable, the functional aspects and the design aspects. And so understand if you're involved in functional pieces, you might not have as much protection there as you think. And then finally, general common themes. These are what I call literary ideas. So British spy, womanizing spy who goes around, killing bad guys with eye patches. That's a general common trope. That's a theme. So just because 007 made it first doesn't mean that Austin Powers then infringes on the general idea. So some of the limitations to our copyright. And I see another, if I represent an artist in business. That's a good question. If I represent an artist in business and file a copyright, it has to be an artist name. So it should be in, so the copyright goes to the person who actually makes the art. But there's what we call work for hire. So if you're an employee, sorry, did everyone see the question? Basically asking, when you file a copyright, who should be the named artist? So whoever makes the work is the artist. Now, if you're an employee, the rules change a little bit. They're still the artist, but it's going to then transfer to the employer. So we'll get into registering copyrights. I might table that any further, and we can kind of talk about those details. All right, derivative work. I kind of talked about this earlier. So a work based upon one or more pre-existing works. It's recast, transformed, adapted, translated, whatever. So J.K. Rowling's Harry Potter books, she has the right, even though it's not her book, of course she has the right to keep other people from copying her book, but she also has the right to keep other people from making derivative works, making works based off of her work. The Harry Potter movies, she had to be involved. She had to be, she had to give permission in order to do that. Similarly, the painting here of the Joker. So the Joker, you could imagine the idea of the Joker and go off and make your own painting. But what they've done here is they've taken, even though it's not a screenshot of the actual film, they've painted very realistically the Joker here, same clothing, same hair, makeup, and recast this character in a painting. That's copyright infringement unless they have permission from the copyright holder. Similarly, a compilation. So that's where you take other people's work and kind of arrange it in a certain way. So the best American short stories of 2019, right? So there is some creativity in putting together this book, but in order to make it, you have to get permission from the people's work who you're compiling here. So the law only protects the new aspects or additions. So someone else can't then go make the exact same collection of short stories. That would be a copyright infringement of whoever compiled this book. But it's very thin. We only protect the compilation. We don't protect, obviously, the underlying stories that other people wrote. All right. So kind of a check and balance on derivative works and the thin rights and the kind of barriers that derivative works pose is the idea of fair use. And fair use essentially recognizes that creative works are built off of others, just like science is built off the work of others. And so there are 4 factors, and there are books and thousands of pages written on fair use, and it's not a cut and dry idea, but these will help us kind of understand how we can use the work of others and at least feel as though we're somewhat protecting ourselves. And these are important things to keep in mind. So the purpose and character of the use. Is it criticism, comment, news? For right now, this is teaching. So even though I've ripped all these images off the internet, I'm not committing, well, I am committing copyright infringement, but I have a defense to that. I won't pay any fines or any fees because this is all an educational fair use scenario. The other aspect of the purpose and character of the use is it transformational? Are you completely changing the idea, the purpose of a work, right? So taking it from factual into fiction is an example. Number 2, the nature of the copyright work, that again, factual versus fiction. Portion use, so if you take a lot of someone else's work for your own piece, that's probably not fair use. If you just take a little and then you add a bunch of your own creativity, now we're headed into safer waters. And probably the most important factor is the effect on the potential market for copyrighted, the original work. So if you copy someone else's picture, add a little bit, and maybe even make it better, and now everybody wants your picture instead of the first one, no good. But if they're different markets, if they're different, so long as you're not harming the other person's market, you're probably in safer waters. So a really good example and kind of a fun example is the Obama Hope poster. So on the left, we have a photo taken in about 2004 from an Associated Press photographer. And on the right, we have the famous Hope poster. Well, AP sued the digital artist saying, you clearly copied our our photo. Just look at them side by side. And the digital artist said, yes, I use your photo as raw material, but this is a transformational piece, right? Some of the factors that we just looked at. I have notes here. The market. Someone's looking for a, kind of more factual, reporting-based picture of a President Obama or then candidate Obama to put on the front page of a newspaper. That's a totally different market than promotional posters meant to further his candidacy. But then the AP comes back and says, well, the portion used here, you used the entire thing. You used his face and, the way that he's looking up. The photographer put a lot of time and a lot of thought into making this expressive work. This is not simple, reporting of the score in a baseball game. There was time and effort put into creating this great photo, which is exactly why the digital artist selected it. And then the digital artist comes back and says, well, I changed this and I changed that. I took out, I added the red, white, and blue. So this is a super, super close case and actually ended up settling before the court ever decided. So it's a little bit frustrating that there's not an actual answer, but it kind of shows that there's always going to be arguments on both sides. And so you have to keep these kind of ideas in mind and understand kind of the limits.
Yeah, and actually, Christian, there's a question in the chat from Diane Britton Dunham of actually the opposite, I would say, of the example that you just gave. So Diane is an artist. And so if a professional photographer takes a photograph of her artwork, does that photograph in itself have copyright of the image of
Right.
her art?
So I'll go back to our derivative work slide. So is this photograph recasting the painting? Well, it's not an exact copy, right? It's not a painting itself, but it's recasting it in a photo. And so do they have copyrights? Yes, but they're infringing your copyright in the underlying work. So if they have permission to take the photo, then they have copyrights. If they don't have permission, then it's an infringement, and they actually don't. You can't have rights in a piece that you weren't allowed to make in the first place. So if a professional photographer comes and photographs your work, if that's something that you allowed, there's an implicit license there to take that photograph, and so they probably have a copyright. And basically, it's something that you should work out beforehand. Let's have a contract. Okay, I'm going to pay you to make these photographs. You're going to give me the photographs, and you're not going to keep any of the rights in those photographs. Or you want to come take a photograph of my piece? Okay, you get a derivative work. I'll grant you a derivative work right in my piece, but I want $5,000, or I want a 5% royalty on any copy of that photograph that you sell. So I hope that answers your question. The answer is yes and no, but more importantly, it's something that we want to get talking about before they show up. So if it's something that you're allowing them to do, then it absolutely is something we should be kind of hashing out the details and writing beforehand. If they just break into your studio and start taking photos and posting them online, that's copyright infringement, and they don't have copyrights in something that they weren't allowed to do. Okay, so great segue. Third takeaway, be proactive now, save time and money later. I'm gonna try to move a little faster so we can get through here, but advocate for yourself. Take yourself seriously, and other people are gonna take you seriously. Do not be discouraged from asking questions, from being assertive, from putting things in writing. A handshake agreement leaves way too much not said and not understood and our brains are just fuzzy. We can't remember exactly what we agreed to. So it's best to have it in writing. So number one way you can advocate for yourself, register your copyrights every single time you're done. It costs $45 to do it. And there's so many benefits. We're going to get to that in the next slide. Number two, get in the driver's seat. Do not be afraid of contracts. They are very powerful tools that, if wielded correctly, are going to save you so much time, effort, money. Some examples, right? So if you're a friend of mine and I were just talking about this, okay, I'm gonna commission a piece for you, and you're gonna put half of it down. Well, go the extra step. Is that a refundable thing? Can they just come when you're 90% done and say, I don't want that anymore, give me my money back? Say this is a non-refundable deposit. If they're serious, they're gonna say, okay, great, no problem. And if they're not serious, then you avoided an issue right from the outset. Put in time limits. Are you giving this person your work to sell forever? Do they have a month to sell it? Do they have a week to sell it? How long are you going to give it to them to display? How many copies are they allowed to make? These are all things that we should be putting in writing. And like I said earlier, include the rights, only the ones that are necessary for the deal, and keep the rest. If they're making copies for you, but they're not allowed to sell it, put that in there. I'm giving you a reproduction right. I'm keeping my distribution rights. Now, on the other hand, never sign a contract the day you receive it. I don't sign my lease the day I receive it. There's just, not only do you not have time to read it carefully, but it's also a little bit of an assertive power move to say, I'm going to look this over. I'm going to consult with my attorney. Spoiler alert, you don't actually have to have an attorney in order to tell someone that you're going to review it with your attorney. Wait a week, wait a day, whatever you need. No contract, like I said, handshake deals are very scary. They're no good. So no contract is a red flag. And get everything in writing. It doesn't have to be, some old English 50-page contract to protect yourself. If you have a phone call, if you have, an in-person meeting, a walkthrough, whatever it is, send a follow-up letter, send an email saying, thanks for your time. Like we discussed today, I'm going to send you my artwork, and you're going to have it for 30 days, and we'll split the profits 50-50. Otherwise, you're going to pay to ship it back to me. Easy. And that creates a great paper trail, and people are going to be held to that if you write it. Registration from the U.S. Copyright Office. So how do you do it? This is it. Go to copyright.gov, start a new claim, follow the prompts, just do the required stuff. No need to do the optional pieces. I think the required things are marked with a little red asterisk. It's a $45 a piece, which, if you're pumping out a ton of works, that sounds like a lot, but it's really going to pay off at the end. And upload a PDF. You're already doing that. You're already taking a picture and posting it on Instagram, on your website. And you get that done. 4 to 8 months later, you got your registration certificate. Why do we do that? So first, statutory damages, also called, easier way to understand it, automatic damages. For a lot of up and coming artists, the actual damages might not be as high as statutory damages. So it's really hard to prove how hurtful someone's use of your work was without a lot of time and expense from lawyers. And even if you go through all that trouble, if you're not really well known yet, it might not be that bad economically, but the law has put in statutory damages in order to compensate people who have works that are copied, are infringed, but only if you register, and only if you do that before they start copying. And then the second thing is that you recover attorney's fees at the end of the litigation. So the other person's going to have to pay for that expensive lawyer that you hired. So if hiring a lawyer is a big deal, if that's a big financial commitment for you, then a $45 investment on the front end could mean thousands of dollars that you recover on the back end. All right, so advocating for yourself. A couple examples of ways that a friend of mine kind of redlined in a contract that they were given to either be expressly clear about what they were or were not agreeing to, or in some cases completely flipping the obligations and making it better terms for themselves. So artist agrees to be solely represented by the gallery within Canada. So you only get Canada, but what about elsewhere? It doesn't say. It's kind of implied that it's only Canada, but it doesn't say only Canada. It just says within Canada. So add in there, artists may be represented by other galleries in the United States. Done, easy. You've worded off a problem. Gallery agrees to represent and promote artists to the best of their abilities. That's a great thing, right? Be super clear. Artist retains the ownership of the artwork even when it's at the gallery. They're just showing it. And then finally, flipping those terms on their head. Instead of the artist assumes the cost of shipping, the gallery is going to do it. I don't need you. I don't want to pay for that. You're going to pay for it. You're going to insure it. And then if you don't sell it, you're going to pay for it to come back. Okay. What if someone is copying my work? So we've written a contract, we've put things in writing, we've been super clear, but unfortunately, someone's copying my work. There's a few things that you can do to save yourself a little bit of time and money. First of all, get a referral from an attorney, from someone you know and trust. The internet's a great thing, but just going on and Googling copyright lawyer is probably not going to be the best way to fit your needs. So start networking with other people. Start asking them if they've ever talked to a lawyer about their infringement. And that could be a great way to kind of find someone that you trust. Second, start doing some of the work. Create a folder. You did that copyright registration, right? Get the certificate, get the correspondence with the Copyright Office. Collect all those letters and emails that you wrote, memorializing all the things that you had agreed to between the parties. Or that someone just randomly was copying, and hit them up and say, you're copying my work. You need to stop right now, or we're going to have to involve lawyers. Take screenshots, take evidence, journal, take notes in each day. Here's what happened. Here's what I discussed with this person. Here's what they said. And then take that all to your attorney, and that's going to save them a lot of time and therefore you a lot of money. Is there a lot of case precedent for college artists losing in court because their works weren't transformational enough to represent a new expression? College artists, I wouldn't say that that's necessarily like an important piece, but yes, is there case precedent for people being infringers because there wasn't transformational enough? That's certainly something that we run into, right? So the piece here, the Associated Press had a lot of good arguments as to why, even though this digital artist did a lot of changing, why this was not transformational enough. I think it was probably fair use, but the AP would argue, well, there goes our entire business model. We license stuff out for pretty cheap. If you let this person copy, everyone else is going to start copying. So the law does not give you a free pass just because you're a young artist or because you're getting into the biz, right? Justice is blind. And so the kind of tenets and the kind of ideas that we're talking about today are going to matter regardless of who you are. All right, selling versus licensing. So when you sell a piece, first sale doctrine says you give up that piece, but the owner doesn't get the copyrights. They only give up the copyright. The artist only gives up copyrights if you expressly put that in writing. Similarly with licensing, remember we can give away certain idea or certain rights and not others. So keep on to the things that you need to, or that aren't necessary, and only license away the things that are completely necessary. And feel free to get creative. Time is a really good way. Put time limitations, put number limitations. I'm going to skip the NFT one, and we can come back to that because it's I've been talking for a while. So are there any other questions as we kind of open it up to the group, and I'm trying to.
I had a question.
Yeah.
That's kind of a follow-up. So about the collages, because I've been thinking about this, and I almost because obviously collage, you're like using other people's work. It seems it seems really difficult to say, or maybe it's easy, I don't know, like because a collage is literally using someone else's work, it almost feels like everything would automatically be like you're walking on like you're walking a very thin line, or maybe it's like it's not a thin line and like you could be sued at any time. I don't know. Does that make sense?
Yeah, no, absolutely. Absolutely. I mean, no one's going to argue that collages aren't an art form, right? So we understand the intrinsic value and the transformative value that collages have. Of the fair use aspects, I think the two things that you want to think most about are the quantity and quality of the piece that you're borrowing from. So if you're taking the heart of a piece and using that as the heart of your piece, that doesn't seem fair, right? But if you're using an aspect that isn't the absolute essential piece of another artist's work and putting it amongst a bunch of other different things, you've now protected yourself in some ways from being charged with copyright infringement and having to pay damages. The second thing I want you to always think about is the market of the piece that you're borrowing from. So is your piece going to be a replacement for what you're borrowing from? So is someone else going to go hungry? Is someone else going to not be able to pay their bills because Brandon's piece is way outselling my piece and they're competitive? Or are you borrowing something that's got a totally different use? It's news, or it's that's political, and mine's kind of like related to like the Obama poster, and then mine's related to something completely different. That's going to also help you. And then the third thing we didn't really talk about before, but if you're commenting on that person's piece and basically poking fun of them or trying to make a comment on their piece, that's protected as parody. Whereas if you're just using their work as a shortcut, SNL does this a lot, right? They use the Jeopardy theme to make satire about society in general, and that's copyright infringement. You can't do that. You're just shortcutting, using someone else's idea to try to make a social commentary in a larger aspect. Why don't you go out and use your talents to find another way to use that, or borrow someone else's expression? So I hope that kind of answers your question on at least ways that we can think about protecting you and getting out in front of some of these concerns before they become a problem.
Mm-hmm. Thank you.
Yeah.
Yeah, I've got a question about registering copyrights.
Yeah.
So if you set up an LLC for your artistry or art business, would you go about registering the copyright in your own name or the business name?
So do you have a employment contract with yourself?
I don't. I just planned to do the I forgot what it was specifically called. It was called something draw, as a form of payment to yourself from the LLC.
Mm-hmm. So as the artist, because you're not employed technically by this LLC, you're using it kind of as a way to, there's a lot of very good legal reasons, right? For tax purposes, for liability purposes, and protecting yourself. And so what you should do is register the copyright in your name, and then you can transfer the copyright, assign it to your LLC, so that then your LLC can license it out to different people. and then the LLC is actually receiving the money, and it has the ability to do that. But as the artist, it's the moment you fix it in your tangible medium, you are the owner of that copyright, and you have all the wonderful rights and responsibilities that come with that. That's what I would do, and we can talk about that more, and I can dig into that a little bit more if you want, kind of on the back end. But that's my initial impression of kind of what we're talking about.
I just had, just since you answered that, I had just a little bit. So if it's assigned to the LLC, when I would be signing a licensing agreement with a brand or a company or business, whoever, they would be signing that agreement with the LLC business name, not me directly.
Right.
Okay.
My understanding of what you're talking about is that you would assign it to the LLC, and then the LLC would own the copyright and then be able to monetize that out, and then that would be the line on the contract, right?
Yeah.
Philip Logan LLC, CEO Philip Logan, boom, sign, you're good.
Yep.
I had a couple follow-up questions.
Yeah.
So I do business with my cousin who's an artist, and he's in prison right now. And so a lot of the legwork I have to do for him. And that's why I ask if if I am the person that files that for him, so will I file that and I guess under own name, put his name? Is that how that should work? Or how does that form look, I guess?
That's a good question, whether you're like filing. So my understanding is, and I'd have to look at the exact language of it, but my understanding is that the artist has to sign it in order for the copyright registration process to go on. So unless they assign the copyrights to you on the front end, and then you have the ability to kind of file the copyright on their behalf, like because you are now the owner, they are going to have to somehow sign that copyright registration certificate or application in order for it to go through. So your business partner, they're the artist, they're the one creating the art. Is that true?
Mm-hmm. Correct.
Right. So the good part is we don't need a registration in order to actually have the copyright. So he's protected with the copyrights. But as I preached, it's a matter of process that we should get very comfortable doing. And there's a lot of very important benefits to doing that. I'm going to look in and go through kind of the process again and just kind of see, but I'm pretty sure that the artist, the owner of the copyrights at that time, has to be the one to sign. And unless it's their attorney or or you have a like a power of attorney type of agreement with them. Now, if you set up kind of like Philip was talking about, if you have kind of an LLC and you can have your cousin assign their copyrights to the LLC, and then now you're a signatory for the LLC, that's a more creative way we can kind of get around that. Okay,
absolutely. And I had a follow-up. So let's say I do file a copyright and it does get approved and somehow it's through the system and it's under my name. And for whatever reason, there's litigation later. Does that make my copyright now void or invalid? What does that look like?
Well, the certificate could be, if they dig in and they say, hey, the person that signed this didn't have legal authority to sign this, so this registration certificate's out. That could be litigated, but you're not, by filing an improper paper, you're not going to lose your copyrights outright. They're still infringing. You still have the ability. And in order to get into court, you're going to have a valid copyright registration to begin with. We talked about that earlier. But yeah, it's an interesting structural issue. And I wonder if there's not some carve-outs for people who are unable to sign, or they're minors. Well, I guess minors would be their parents, but people in prison, it can't be a new problem. So I'll look into that a little more. But I think my understanding is the best way would be to basically have them write out, say, I assign the copyrights in this work to William Spencer. And then now you're the copyright owner, and then you file. Then it's legitimate. Now, you got to have a good agreement, and you should have an agreement before that saying, you know, I'm going to license, or I'm going to grant you these copyrights, I'm going to license you these copyrights, but we're going to share equally in all the profits, or I'm going to get all the profits and they just get the license, right? So there's way to get them over, then you can file, but let's get that in writing beforehand so that everyone's crystal clear about what's going on, and you have a paper trail, and you have kind of just clear understandings. Does that make sense?
Yep. Thank you. Appreciate it.
Yeah.
I've got another question if nobody else has something to ask right now.
Yeah, go for it.
So, okay, so we've established, you know, I would be signing, so register the copyright in my name, assign it to the LLC, then the LLC can license it out to whoever would want to, you know, license the images. But once I'm signing the contract, is there a period of time where I need to kind of wait to assign that copyright to the LLC, or is that kind of in that same just initial copyright process?
So is there a time you need to wait between assigning and going to the copyright office? Sorry,
I can give you a scenario that may help it a little better.
Let's do a
So-
hypothetical. We love hypotheticals.
Okay, so I pitch an idea to a company and I end up shooting something for them, but before I return the images to them, I want to copyright the images so that they're protected, and I'm basically licensing those images to them. Now, when I'm assigning those images copyright to the LLC, is there going to be like a waiting period? Because I wouldn't want it to kind of disrupt the turnaround time for a project.
Right. So the registration process takes like 6 months.
Okay.
So, but it's retroactive to the date that you filed it. So if you take a picture and you file a registration with the Copyright Office on today, right? And then, well, first assign the rights to your LLC. The LLC files the registration with the Copyright Office. You click submit, you pay your $45, and then you can send them to the company that you're trying to license them out to. Now, what I want to make, if they're hiring you, I would always put in there that you're an independent contractor, because there's works for hire where if I'm hiring someone, they're my employee. This is what I hire them to do every single day, to go out and take photos of the park or whatever, because I have to work all day, but I want to see pictures of birds. And they're my employee. They don't own the copyright when they take that photo. They're my employee. They're doing what is within my employment contract or whatever. The company owns that. So, but if I hire an independent contractor to make a special statue out front of my house, I buy that piece from them, but they retain the copyrights. And so watch out for that phrase, work for hire. If you see that in a contract, redline the shit out of that and say, no, I'm an independent contractor. I'm retaining all the copyrights, and I'll sell them to you, license them to you, whatever, down the road. We can have that conversation. So just kind of look out for that.
Cool. Thank you.
Yeah.
All right, so we are at the top of the hour, bottom of the hour, half hour. If anybody doesn't have any last minute questions, I know somebody had asked about the slides. Christian, would you be comfortable sharing the slides with me so I can share it with some of the artists?
Yeah, absolutely. No problem. I don't think I have anything I'm worried about. So
cool. Yeah, and so everybody knows, this meeting was recorded, so I am going to distribute it to our email group and Slack group as well. But if anybody has any more questions, feel free to reach out to me and I can try to send them their way to Christian to get his input. But thank you again, Christian, for being here. We really appreciate all of the input. This was like extremely helpful.
Awesome. Thank you all for having me, and thank you for being engaged and asking awesome questions. It's super fun.
All right.
Christian, I got like two more
you.
for you if you have the time.
Yeah. Anyone can hop off. You're not gonna offend me.
So one of the things I was wondering was what has precedence, copyright or trademark? Because if I trademark our logo, for instance, which one I guess is more important under the court system?
That's a good point. So where do I start? So trademarks often are very simple, right? So there's not perhaps a lot of protectable expression in the Apple, right? Let's take Apple, for instance. If I sketch out the Apple logo, you wouldn't have to change it very much in order to have it be different. And there's not many protectable aspects in the Apple logo. But if you're using it as a source identifier, trademark law also has a somewhat low barrier to entry. And so as soon as you start using it as a trademark, you start using that image, that logo as a trademark, you have trademark rights in the area that you are using it in. Now you can, just like the Copyright Office, go to the Trademark Office and register it, and now you have nationwide protection for that piece, for whatever goods and services that you're using. So they overlap in terms of, if I make, what's a good, like, kind of detailed logo? I can't even think of one right now, but you know, the more detailed that your logo is, the more copyright protection you'll have. But as soon as you start using it as a logo, now you're into trademark law, and you're able to prevent other people from using that thing or a confusingly similar logo for the same type of goods as you're concerned about. Does that kind of make sense?
Yeah, absolutely. And then why does the perception out there persist that, you know, just the creation of the work is not enough to protect yourself in a court of law?
You're saying that before coming here, there was a conception that, like, just because you made it doesn't mean you have copyrights in it?
Yeah, that's my perception. I guess maybe it's limited.
Yeah, absolutely. No, I think that's totally valid. Well, it is true that you can't go sue someone until you do go through some of these formal aspects. But a lot of times it's because people are trying to screw you out of, you know, the rights that you have, and they're trying to lie and cheat and steal and say, you know, I have more power, I have more money, I have more whatever, and you know, you don't have as much protection here as you think. And you know, it's true that copyright law and intellectual property law in general, you know, it tries to even the playing field a little bit, but the more resources you have, you know, the longer you can kind of take on these battles. But hopefully that's one of the things that you learned here today, is that, you know, the poet who's sitting out there and writing poems and selling them on the street, you know, they have as much copyright in their work as, you know, a famous artist commissioned to put a new statue out front of, you know, some government building. So now you can be an ambassador for everyone else and say, you know, no, you have rights and power here. Okay, we have another one. How long can I claim copyright for work that is sold? So that's a good question. Oh, and in the NFTs, yeah, we can do that for sure. So like we said, copyrights last for the life of the author plus 70 years. So as long as any of us will be concerned about it. But a work that's sold, I'll go back to first sale doctrine here. So the sale of an individual piece does not imply the sale of the underlying copyright. However, first sale doctrine says that the new owner of that physical copy can sell or dispose of that particular copy in whatever way that they see fit. So I can move it around, I can borrow, I can lend it to someone else, but I start making copies. Let's think about it this way. If I buy a book, if I buy Harry Potter, great. I bought the book, I can lend it to Toddy. I can even sell it to my girlfriend and make some of the money back after I read it. I can do whatever I want with that specific book, so long as I'm not infringing on the rights, the copyrights that I didn't even buy in the first place. So I can't, just because I went to the bookstore and bought a copy of Harry Potter, doesn't mean that I can go Xerox Harry Potter every single page and go sell it for half the price on the corner. That's the copyright, that's the distribution right. Nor can I put a camera up and just blast it up front of my house. That's the reproduction right, or the display right. So first sale doctrine says that once you let go of that piece, you no longer have control over the physical piece, but they can't honestly even post it to Instagram and make digital copies reproduce that piece without your permission. And you can go to Instagram and say, this is my piece, I am the copyright owner, you need to take this down right away. And they'll do it. I mean, you got to have a little bit of evidence usually. I haven't actually gone through the Instagram process, but there's some pretty strong protections. So yeah, let's do the NFT one, unless anyone else has any like more pressing questions. But I think this is a really fun case study on why being attentive and being proactive can be super important. So first of all, what are NFTs? Non-fungible tokens, right? So fungible just means kind of like replaceable, one for one. So I don't care if Toddy owes me $10. I don't care if she gives me $10 bill A, $10 bill B, 2 5s, whatever. It's all interchangeable. It doesn't matter to me that it's a specific $10 bill. Whereas non-fungible tokens, or these digital pieces, are one of ones. They're not transferable. It's unique. And so it's just like a painting, right? You make a unique painting. It's a one of one. You can't switch it out for some other painting because that's a different painting. So in some ways, non-fungible tokens aren't different from what we already understand art to be. But what they are not is they are not the copyrights themselves unless you're agreeing to that. So when you buy an NFT, you're not buying the rights to that worldwide, you're buying that NFT. And guess what? Like, it could be a copy of a clip that exists in some other fashion. So they kind of only have the value that anyone else says they have. But be very wary as artists, as creators, to go on to these websites. It might be really, tempting to go on and try to get in on the money grab that's going on right now. And this is where it becomes really important to read the fine print. So some of these NFT generation websites, they acknowledge in their terms and conditions that their copyrights are not involved. This is simply, a specific digital copy of your piece, and you're selling it through this website as an NFT, and you're promising to only make 1 or 10 or whatever it is. But this Mintable website actually says, under the copyright section, that the transfer of this NFT transfers the copyright to the buyer of this token. It'll be stored in the blockchain, whatever reference, so you know who does it. But by choosing the Mintable website versus some other website, you now have given up every single one of your rights. You can't even go and post your own photo of your, or a digital photo of your work if you sold the NFT of that work to someone else, because now they own, and you've got to go license your own piece back from someone else. So always read the fine print, always be, careful about what you're signing, and protect yourself, because, the details matter.
I had a quick question here.
Yeah.
It was going back to the registration of a copyright.
Mhm.
So let's say I didn't register. Let's say I didn't register copyright on a piece, and then someone later on copied it. Would I have to go back and then register it as part of my case, or at that point is it moot?
Correct word.
To do so.
Right. Absolutely not moot. And it's a prerequisite. You're still, so that's where, okay, so I'll take it one step at a time rather than just cascading all this information. Not moot. You still have plenty of time. You can still sue them. They will still be in the wrong once you win, right? And to go to court, you have to register your copyright. That's the last point there, enforcement of rights. So the reason why, basically the government creates incentives to buy into this program, and they have their own incentives to create the incentives, right? $45 times 1 million registrations is a shitload of money for the US government. So in order to convince you to pay them that small fee, they created a law that gives you extra rights if you do it before the other person starts infringing. So the two extra rights you get are that you might get statutory damages, which is an alternative to actual damages. So Brandon, if you can show that someone copied your work and made $10,000 off of that copy, that's a 1-for-1. That's your actual damages. That's the actual money that you didn't get that someone else got. We don't have to worry about statutory damages in that aspect. But if it's kind of hard to prove how you were actually injured, like they copied, but did it matter? Did you make any less money? Did they make any money? Who knows? That's when the statutory damages can come in. And it actually was made really famous by all the Napster like music stuff, because every time you downloaded a music, it was only like $1.99 of actual damages, but because the music industry has a large lobbyist, it was like $30,000 of statutory damages. So you rack up 100 songs, and now that's, a lot of money in statutory damages. So for smaller artists, it can be helpful because we don't have to prove actual damages. And even if we went through the process of proving actual damages, it might not be as high as statutory damages. The second thing we get is that we make the other person pay for our legal fees at the end if we win. And that can be a really great tool if paying for a lawyer is not something that's easy to do, because no one likes to do that. Sorry. So those are the benefits, but certainly the boat has not left the port on you being able to sue that person. It's something you're going to have to do anyway. And so, great, fine, I'm not going to get statutory damages, and probably wouldn't even go all the way to trial anyway. They're going to want to settle and say, Brandon, I'm sorry, here's whatever amount of money, let's settle. But yes, you have copyrights the moment that you fixed it. They were wrong the moment they copied it, and you can go register your piece at any time. Anything else?
Christian, I have a question. So say, for instance, I do a 4-piece series, Does that, within that series, I have to get all 4 pieces registered, or can I just register it as a series?
So there are some options for registering multiple pieces at once. It's a higher fee. I think it's like $65 or something like that. So you do save some money. Luckily, the Copyright Office has made their registration process pretty like common language. There's not a lot of legal jargon. So, read the fine print, work your way through. There's a lot of great articles online of how to register your copyright, and a lot of great stuff on copyright.gov. But yes, they've thought about that. They've said, okay, well, if someone's making a whole portfolio of photographs, they're going to want to do that all at once, right? You could take 100 photos in one session. And so they charge a little bit more, but they allow you to do kind of a portfolio.
Okay, that's what I need to know, because it's
Yeah.
like, oh my God,
I know
I
that
have like,
it could start chipping away.
yes, but it's not turning to pay for it, and it's like you want it to be able to turn to pay for it, so you don't be out of pocket. Okay,
Yeah,
that makes a lot of sense. And then I have one final question, and I'll let you go. Where do we get artist contracts at? Do we create our own, or is there a template out there?
there are definitely templates, and law, just like art, just like science, builds off of the work of others. So you see one thing that you like, and then you see another thing that you like, and you combine them together, and now you got something you really like. I don't have like a repository myself, but I do know that there's some really great websites. I think I had it on the tip of my tongue. It was like plagiarism week. That's not weekly, but it's like plagiarism. I want to find it. Plagiarism Today. I like their website. I think they make a ton of good, easily digestible content, and there's actually a pretty cool like stop internet plagiarism. Pete, can you all see this yet, or are you on the other side? Is that it?
That's it.
Okay, cool. Yep, they got a lot of cool stuff on here, and how to stop, a step-by-step guide, and when all else fails is the attorney part. So there's 4 steps to dealing with plagiarists and people who are copying your work that I think is great. And so I'm not sure if they specifically have like example contracts, but there are good websites out there that will, of course, for a fee, sell you a contract. But I think this would be an awesome opportunity to network with other artists that you know and say, hey, does anyone have some good contracts? Does anyone have some bad contracts that they signed and they really regretted it? Why? Okay. What was in there? What screwed you? And how can we get together and understand how we can write this thing to benefit us? And if someone sends you a contract and you don't understand it, or there's something in there that's kind of wordy, be like, we're either taking this out or you're going to have to rewrite it. And you're going to have to explain to me what you're trying to get at. And then we're going to write it in a way that I understand. Because, even though lawyers like to make contracts really complicated and legalese jargon, the law does not like that any more than a super concise, normal everyday language contract, 1 page that puts out every single term and says, here's how long you have it, here's what you can do, here's who's paying the costs, and here's what happens if it goes wrong.
Okay.
So yeah, collaborate, get creative, and